Welcome back to The Explainer. Let's just jump right in today, because we're unpacking something I found absolutely fascinating in our source material on modern financial defense. Okay, imagine looking directly at the high-stakes 2026 financial landscape. In this kind of environment, protecting high-value private equity, it isn't just a luxury anymore, and it's definitely not an afterthought. It is an absolute necessity. The financial terrain out there is constantly shifting, and the strategies for insulating private capital from future litigation, well, they require a level of precision that just goes way beyond traditional, old-school methods.
In fact, there's a quote straight from the source that perfectly sets the stage for us. It says, "Sovereign wealth management isn't just for the ultra-elite, it's a strategic necessity for anyone protecting high-value equity in 2026. We are moving beyond surface-level tactics to show you how precise trust law can insulate your capital from any courtroom battle. Discover the mechanics of making your wealth truly untouchable." Now, what I find incredibly crucial about this framing is that we are not looking at aggressive, shady practices here, not at all. We're exploring a strictly necessary structural legal strategy. It's all about using the established rules of the game to ensure total asset insulation.
Untouchable wealth, right? I mean, that is the ultimate goal here. Reading through the source material made me realize that we really have to move way past basic everyday protection. This is about taking trust law and effectively weaponizing it as a defensive shield. Because this isn't about hiding assets, it's about fundamentally redefining how those assets are owned, so that they simply cannot be reached by external creditors or unforeseen claims. We are essentially building a fortress, and the mortar holding the whole thing together is pure legal precision.
So, you might be wondering, how do we actually build the architecture of this fortress? Well, it all comes down to fiduciary frameworks. Think of these as the foundational blueprints for creating an impenetrable financial bunker. If ownership is normally just a straight line between a person and their money, this strategy takes that line, bends it, reroutes it, and then locks it behind multiple legal blast doors. You're insulating private equity by changing the very nature of who actually owns it in the eyes of the law.
And here is the absolute core mechanic of this entire strategy. We are severing legal title from equitable interest. Guys, this is quite literally like splitting a financial atom. By separating the person who holds the legal title, meaning the name actually on the paperwork, from the person who holds the equitable interest, the person who actually benefits from the wealth, you create this incredibly powerful structural separation. It's an impenetrable barrier. Think about it like holding the keys and driving a car every single day. But legally, your name is nowhere on the title. If a lawsuit targets you, they find zero legal ownership to seize. If they target the legal owner, they find no actual benefit to take. The ownership is severed, and the asset is completely insulated.
To reinforce that severed title, we look at discretionary structures. In this framework, the beneficiary actually has no fixed rights to demand the money. The trustee holds all the cards. The trustee has the absolute discretion to distribute funds, or, and this is key, to withhold them entirely. And since the beneficiary can't legally force the trust to hand over the cash, well, neither can a creditor. By deliberately limiting fixed rights, you are deliberately limiting creditor access, which keeps external threats entirely at bay.
Now, throw spendthrift provisions into the mix. I know, spendthrift sounds like an insult straight out of the 1800s, right? But these clauses are actually the next impenetrable layer of our fortress. They strictly prevent beneficiaries from giving away or selling their interest to someone else. And why does this matter for your own portfolio? Because if a beneficiary cannot willingly transfer their interest, a court cannot force an involuntary transfer to a creditor. It completely blocks unforeseen claims and literally stops courtroom battles in their tracks, ensuring the wealth stays entirely insulated within the structure.
But look, all of these incredible legal structures, they're really only as strong as the ground they're built on. Which brings us to a fascinating concept: global jurisdictional arbitrage. You aren't just looking for a heavy bank vault. You are actively looking for a sovereign legal system that heavily favors asset insulation and fundamentally limits the reach of outside litigation. It's the strategic selection of exactly where in the world your trust actually lives.
When you compare the data side by side, the difference is honestly striking. On one hand, the latest 2026 domestic asset protection statutes give you a really solid baseline of security, but you're still ultimately at the mercy of domestic federal overrides and local court jurisdictions. On the other hand, look at premier offshore havens, specifically places like the Cook Islands and Nevis. These jurisdictions have built their entire legal frameworks around protecting trust assets from foreign judgments. While domestic statutes provide a good start, the offshore havens offer a structurally superior barrier against domestic courtroom rulings. It's pretty amazing how a tiny tropical island can legally hold off major domestic courts. But hey, that's the pure power of jurisdictional arbitrage.
But what if you want the best of both worlds? Well, the source material introduces this incredibly innovative hybrid concept called the bridge trust solution. I like to think of it as a legal escape hatch, designed specifically for the unpredictable 2026 landscape. It acts as a bridge between the comfort of domestic laws and the ironclad protection of those premier offshore havens. It basically allows you to maintain your assets domestically when the skies are clear, while giving you a structural mechanism to instantly move them the very second a threat appears on the horizon.
In practice, it's this brilliant two-step dance. Step 1 gives you local control. The trust is managed domestically, providing ease of access, standard compliance, and that everyday comfort right at home. But the magic happens in Step 2. The moment a legal threat pops up on the radar, the emergency offshore trigger deploys. The domestic trustee steps away, the offshore trustee in a jurisdiction like the Cook Islands takes over, and instantly, a legal blast shield drops over the assets. It is dynamic, real-time asset insulation.
Of course, drawing up the blueprints is one thing. Actually pouring the concrete is another. This requires construction, physically and legally moving specific asset classes into the newly structured trust. It's not enough to just sign the paperwork. The private equity, the real estate, the liquid capital, all of it must be formally transferred into the fiduciary framework. This is the tangible, real-world step where that severing of legal title from equitable interest actually takes place.
So when we distill all this down, true sovereign wealth management absolutely requires a synchronized strategy. It means weaponizing trust law against litigation to sever legal title from equitable interest, creating that atomic-level barrier we talked about. It means layering in those discretionary structures and spendthrift provisions to absolutely deny external creditors any leverage. And finally, backing it all up by executing jurisdictional arbitrage, perhaps using a bridge trust, to ensure the legal environment heavily favors the defense of your capital. It's a complete redefinition of ownership.
Which really just leaves us with one final critical question to ponder today. Is your equity truly untouchable? Because as the 2026 landscape clearly shows us, surface-level tactics simply won't cut it anymore. Take a moment to think about what this means for your own legal frameworks and whether your assets are fully insulated against unforeseen claims. Thank you so much for joining me for this explainer. Keep questioning the structures that surround your wealth, and I'll see you next time.